question about city reports that just popped into my mind. If there is something that's still open, even though it might be 5-10 years ago, as a listing agent, what do you think we should be doing about that? Should we be on the phone with the city trying to get something
No.
just simply
Just
Okay.
disclose it. Disclose it.
But there's still an open
Anything
permit.
you know, anything you have, must be provided to the buyer, right? Either in a disclosure format or the actual document and receipted. I can't stress enough the importance of getting a receipt. When you're providing buyers with documents, use the CAR receipt for reports, indicate the name of the report, the date that it was generated, and how many pages you're giving them.
Okay, so conversely, if we're representing the buyer and we see a city report, which we usually don't see till pretty much close to the end of escrow, if we see a city report with something open and we're representing the buyer, should we be encouraging them to go to the city and
Well,
see
if
why
they've,
it's open?
look, if the buyer's already removed their contingencies, it's a little late.
It opens it up though.
No, it doesn't.
If there's a new disclosure,
Well, it doesn't if it's what this lady's describing, the permit issue, because if they've signed off on everything, removed all contingencies, remember the language of the contingency removal form, it says, if I remove all contingencies, I am agreeing that all my contingencies are satisfied, even for those items for which I have not yet to receive documentation. So if they're items the seller was supposed to deliver under their obligations under paragraph 4A, then 14A, then it could be too late. But nonetheless, the buyer has the information. The buyer can still ask the seller to make corrections. The seller can say no, because remember the other language in the contract. This is what's so important, that knowing the tools of our trade. The contract tells us clearly that the buyer is to be aware that the property may or may not be to code, that the property may or may not comply with local laws and ordinances. There is no requirement for the seller to bring a property to code, no requirement to make it comply with the law unless it becomes a contractual condition between buyer and seller. The contract tells the buyer, look, you investigate. You've got 17 days to do all your investigations. If you find out that there's something wrong, you can come to me via a request for repair, and I can say yes or no to your request. The disclosure is what's critical, the disclosure of the information. And the buyer has to understand the importance of their due diligence. Remember, in California, the civil code that governs our disclosure obligations also governs the buyer's duty to themselves. They have a duty to protect themselves, a duty to investigate. Yes?
But based on what you're saying then, because we get our city reports, especially now that you're late, not within the 17 days. So you're saying if they do remove their contingencies, so then should we tell our buyers to go to the city and investigate during that 17 days?
You know what I would do? I would remove all of my contingencies with the
Okay.
exception of, I use paragraph 2, with the exception of the city report, because the city report is one of the seller's duties to provide under paragraph 14A, and if he doesn't do it and it's delivered late and we've protected the buyer by not removing the contingencies, then the buyer may have 5 additional days to review that report and make their decision. But if the buyer just willy-nilly removes all contingencies without accepting that issue, because that is part of the seller's obligation in the contract as a city requirement, a city mandate. I think your Ventura, a city one, is a city mandate.
yes.
It is.